May it please the court, my name is Terrace, initials GT, and appear for the accused. My client, Mr. Lowtower, has been accused of possession of more than 200 grams of MDMA pursuant to Section 9, Subsection 1, Subsection A of the Drugs Misuse Act. The defence submits an application for a ruling pursuant to Section 590, A, Subsection 2, Subsection E of the Criminal Code, that all evidence obtained through the vehicle stop conducted on 1st June 2024 by Detective Senior Sergeant Targayan should be excluded from trial. It is my understanding that Your Honour is familiar with the facts of the case, and if it pleases the court, I will dispense with recounting the factual background. Your Honour, Constable Targayan unlawfully exercised his powers to perform a traffic stop under Section 60 of the Police Powers and Responsibilities Act, hereafter the PPRA, which provides an officer with the power to stop a vehicle to conduct a licence check. In reality, the constable's intention was to conduct a PPRA Section 31 search of the vehicle to find my client offending against the Drugs Misuse Act. Constable Targayan had identified my client's passengers, Mr. Crispin Cold, and thus set out on an expedition to find the drugs in the vehicle my client was driving that he already predetermined were in the vehicle. If it pleases the court, I seek leave to dispense with formal citations. The senior constable gave evidence that he had already come to a firm conclusion that he would intercept the vehicle to search for drugs based on prior knowledge. As my client was adhering to the relevant laws contemplated in Section 60, there was no apparent reason for a traffic stop to be conducted. Davis firmly established that using Section 60 as a method of interception is only lawful for the purposes of a traffic stop, and not as a way to subvert the operation of Section 31. The senior constable initiated a traffic stop with a preconceived bias that my client was associated with a member of the Green Traders and therefore was trafficking drugs. Senior constable neglected the importance of observing due process and chose to use a license check as the interception method instead of the more appropriate Section 31, where he could have relied directly on the gang status of the passenger and the higher vehicle tip-off and the interception command on the Q light. Justice Davis found in Hines Rabbit that even though the vehicle was a hire car, the time of night and the officers could identify the person in the vehicle without Q light, this was not enough evidence for the officer to form a reasonable suspicion to conduct a search under Section 31. However, in Davis, there was evidence that related to the area the vehicle was in the time of night and the interior of the vehicle having marks consistent with drug trafficking. His Honour identified that this was enough to meet the reasonable suspicion threshold identified in Section 31. Evidence in this case meets somewhere in the middle. However, it leans more towards the threshold in Davis, and therefore Section 31 should have been applied. The choice by the senior constable to intercept my client under Section 60 instead of stopping him under Section 31 is a breach of statutorily vested power, and the evidence should be rejected as a matter of discretion. This is the Ireland principle. My application for Bunnings and Cross direction is as followed. Davis and Hines Rabbit established that circumventing Section 31 through use of Section 60 is a deliberate disregard of the law. The evidence is not less reliable due to the illegality of retrieval. In Senior Constable Targayan's circumstances, it has been established that it would have been reliable for him to use Section 31. In Davis, His Honour announced the harm of the officer's misuse of statutory power is more harmful than the obvious seriousness of a drug charge. Particular harm to the community that could have been caused had the stop and the seizure not been conducted has since been resolved. The defence submits that the court should make a finding repudiating the disregard for the proper exercise of police powers rejected by their honours in Davis and Hines Rabbit. The PPRA restricts the officer's exercise of Section 31 through reasonable suspicion clause. Public interest in the protection of the individual from unlawful and unfair treatment outweighs the comparison to the seriousness of the offence. Your Honour, in summary, the defence seeks an order to exclude all evidence garnered from Senior Constable Targayan's unlawful search of the vehicle my client was driving from his charge under Section 9, Subsection 1 of the Drugs Misuse Act. Your Honour, should you find that interception under 60 is lawful, I raise the following considerations to exclude specific evidence. The defence submits that the assertion that the senior constable had formed a reasonable suspicion to perform the search of the vehicle under Section 31 should be rejected. In the Queen and Kovacevic, His Honour Justice Burns identified that a hunch was not sufficient to demonstrate reasonable suspicion, regardless of if it was right. It is clear that the senior constable was acting on a hunch in this matter as well, where similarities are drawn from Heinz Rabbit, which also did not meet the reasonable suspicion test. The only interaction between my client and the search in the vehicle with the senior constable was that he was nervous, and in that nervousness stated that it's not mine. Your Honour, the constable did not question what my client was referencing. My client was simply referring to the vehicle not being his. However, the officer took this further to act on a hunch to search for the vehicle instead of questioning my client's response. This is an investigative procedure that any officer with a senior constable's experience would be familiar with. The Christie discretion applied in Australia through the High Court case of Lee should be applied in regards to all evidence relating to the Green Traders. Although Mr. Cold was identified as a member there was no record or reason to believe that my client was a member. The evidence of the Green Trader vest is irrelevant to my client being charged under the Drugs Misuse Act. The fact that the vest was in the vehicle does not rationally affect the consideration that my client was charged with possession of MDMA. My client has no ties to the Green Trader Club and cannot be identified as a member of the club. The Crime Stoppers tip should also be disregarded under the Christie principle, as the evidence is irrelevant to the possession charge. It cannot directly identify my client in trafficking drugs. It merely gives rise to the notion that my client was meeting with other people. There is an unfair prejudice against my client as he has not been formally charged with these insignificant allegations. However, they're being used to portray my client in a negative light and with no real weight to prove the guilt of my client. On these grounds, we seek that all evidence relating to the search of the vehicle should be excluded from trial. If it pleases the court, Your Honour, that concludes my submissions.